It's got to give you a countdown.
Happy Tuesday. I'm Joe O'Keefe. This is
Ryan Gilman.
And we are two lawyers drinking beer and talking law liberally, sometimes with a dog, Jaeger.
Always with a dog, if I can allow for it. Anyway,
Today's our introductory series, and we just decided we're going to talk about real estate law. Let's start with commercial real estate law. Riddle me this, Ryan. When is a common area maintenance fee fraudulent rent?
Probably more often than, in your opinion, than my opinion. But essentially, fraud comes in all types. And in the landlord-tenant relationship, what happens is you have landlords fraudulently misrepresent what they're selling you, right? So you got a landlord, you're renting an office, and that landlord tells you, hey, you're gonna get 6 parking spots, and you're gonna have trees maintained, you're gonna have the outdoor area maintained, and in exchange for that...
let's not forget, your rent and combined common area maintenance fee is not gonna be more than a set amount.
Well, anyway, sometimes that landlords don't keep their promises. So like when you think about that specific example I was giving, a landlord gives you 6 spots, tells you they're going to maintain the outside in exchange for a certain fee, and then you don't get the parking spots, they don't take care of the area, that common area, and then they turn around and charge you more money than they told you they were going to charge you.
All right, look, so common area.
Common law fraud,
everybody knows what a common area is. A common area is that area which is shared amongst the tenants. A common area is not based upon your square footage other than, let's say the building's 10,000 square feet, your common area is 2,000 square feet. Well then guess what? You're responsible for 20% of the common area maintenance fee. What would that be? Parking lot, sidewalks, vestibule, right?
Any things that are shared in common, I guess.
Right, but when you take a fee and just times it by the square footage of your space, that bears no relationship to any maintenance of the common area. That is common law fraud, no matter how you slice it.
Yeah, essentially, when we talk about fraud arises in a variety of commercial contexts, but the crux of the deal is that someone told you something that was not true, and that fact induced you to enter the agreement. There's the difference between what we call puffery, which is you're selling a product, and of course you're going to say your product is the best, and it's all these things. But there's a line drawn, and we call it fraud when it goes to inducing you something such a lie.
Yeah, like your rent and common area maintenance fee won't exceed X amount of dollars, and your common area maintenance fee is also going to be based off of maintaining the common area.
But this also applies even in residential lease agreements.
Well, more so.
More so, because you have certain agreements that landlords will. That's the beauty of a lease, is that it binds you just as much as it binds your landlord. And anything in a lease that your landlord promised you that they never delivered on is grounds to sue them for fraud. And in the landlord-tenant context, at least I just get a lot of people every day who come to me telling me horror stories about landlords, absolute horror stories.
Well, and a lot of the fraud can also be in the inducement, which means that if they're slick and they promise you stuff to get you to sign it, but then they give you this big, thick Bible and they don't put it in there, well, that's fraud in the inducement. That counts too.
So, and honestly, fraud in the inducement's a lot easier to prove. But we deal with all types of stuff when we deal with landlord-tenant relationships. But honestly, what I think overwhelmingly I find is landlords think they have a lot more power than they really actually have. Fraud judgments, I actually am dealing with a fraud case right now. I mean, a similar deal, but it was a funky real estate transaction, long story short. Well, it's on appeal right now, but in that case, what happened is my client essentially sold the house to a group of real estate investors who basically was a rent-to-purchase contract, long story short. The investors, the people who bought this house, completely lied to my client about their ability to pay the anticipated rent schedule and the balloon payment to buy the house. Totally lied about it, and because of how these people structured this deal, it ruined my client's credit. Because what happened was he was still carrying the mortgage on the house. They were supposed to pay that mortgage, and then they stopped paying the mortage.
By the way, hold on a second. So we want to shout out to our host today. We're at FHBeerWorks on Cajon Street, managed by Ms. Monica. Hey, Ms. Monica, do you have a minute here, please? Come on, she's being shy.
She's
She doesn't
busy.
want to go on the camera. You guys want great beer at great prices and most excellent management. Come on down to FHBeerWorks. They even let this dog in who's clearly flagged.
It seems like when you get screwed over, you got no options out there. You're usually out money. You're usually in a tough
Bullshit.
spot. But honestly,
Bullshit.
you always have a remedy when someone lies.
Well, let's think about this. Real property and residential property goes back to the common law, which goes all the way back to the days of when, in England, the sheriff could decide that he likes your wife and he likes your fields, so he's just going to take both and throw you into jail on some trumped up whatever rent charge. So in the United States, we've developed some unique systems that are pretty uniform throughout the states, which is that you always have due process rights to appear before someone to say, wait a minute, I shouldn't be being thrown out.
I mean, and Joe speaks, generally, Joe is correct there. Generally, you have your right to the day in court.
Specifically, I'm right about that.
Well, I would actually disagree. We have a case right now where we have to litigate, where one of the very substantial questions is, do we have a right to a day in court?
Well, yeah, but you don't have self-help. When you don't have, how do you not have a right in court when landlords don't have a right of self-help?
Well, and that's,
first of all, let's explain what self-help is. Self-help is when a landlord decides that they don't need the courts. They're just going to go in and while you're at work and throw all your shit on the front yard and put padlocks on the door or change the locks.
now that's illegal in Colorado.
But that's because it's called
Specifically
self-help.
illegal. Now, not in every state is that illegal.
But it's illegal. Most states it is. It's called
most states
self-help.
it is.
It's illegal.
No, most states they have to get the sheriff's deputies to come.
Well, this
come
is
out.
my point. So then how can you explain that to me?
Well, so first off, you can have an arbitration clause in your lease. Smart landlords.
Are they legitimate for residential leases?
That's an open question, but in Colorado, arbitration clauses have been enforced for residential leases.
Huh.
And arbitration is just a process where, essentially, instead of having your day in court and open court in front of a judge appointed by the governor of Colorado, you have to hire a usually retired judge who will charge you. I've had arbitrators charge $750 an hour before to hear your case.
Or you can wait until they sue you and then you make them pay.
Yeah. But that's the thing is you always need to read your lease very clearly when it comes to this, especially these arbitration clauses.
We're not at all.
all.
There's two things, particularly when you get a lease that's a quarter the size of a phone book, New York City phone book, don't even read it. You know why I say that? Because you rely on what they induced you to sign it, and if they're going to be putting that stuff in there, they're planning on playing games. You'll have plenty in there you can hold against them. Absolutely.
Oh, especially,
It's like washing cars. If you get a brand new car, you either take and maintain it, or from day one, never wash it and let the dirt layer build up. But believe it or not, it'll actually protect the paint.
Actually, Colorado is a Wild West type state when it comes to the statutory requirements of leaseholds. Colorado, up until only a few years ago, did not have what we call the warranty of habitability, which means up until a few years ago, your landlord could rent you a house that had sewage flowing into the living room, and you would not be able to get out of your lease. You would still have to pay, and if you wanted to move out, well, that's on you.
You say sewage, but how about these meth houses?
No, before the warranty of habitability, it was very strict. And in Colorado, I think a couple other states still don't have the warranty of habitability, but Colorado was a very late joiner into recognizing that landlords have a duty to rent you a space that is actually safe to live in.
So we have the fraud statute. What else do you got?
So we have a habitability statute now. So if the conditions of the place you're living are not habitable, that means sewage, things like that.
Sewage, heat, hot water. Yeah, it's basic.
But that gives you an affirmative defense to break your lease. If you give your landlord notice of the condition in reasonable time, the notice also has to be in writing. And they don't fix it, then you have the ability to break your lease. Now, the thing is you also can sue under a premises liability standard. So, like the meth house example. Let's say you get sick. Well, then you can sue your landlord based on what we call premises liability.
Well, let's talk about commercial leases. We got fraud. What else do we have?
Well, fraud's my favorite.
I know. Well, fraud's great.
Well, you always have breach of contract. There's always the issue.
So fraud, breach of contract. What other?
Unjust enrichment. Again, we have these things we call quasi-contract doctrines, which are, let's say you don't have a formal breach of contract because the requirement of contract is very technical. But we have this doctrine called unjust enrichment that basically says if someone made money off of you in circumstances that it's unfair that they made that money off of you, you should be able to get it back. And so that happens in a lot of cases.
Well, but you know, like, all right, so take a situation where you may not have it. For example, one tool you can use with landlords is escrowing money, which means that if you have a dispute with your landlord and you know you want to show the courts that you're on top of your game, what you'll do is you'll take what you think you owe the landlord in good faith and put it in an account specifically for them and for their benefit, right? Pending the outcome of a lawsuit. That's probably one of the smartest tools I would think you use, because nothing's going to ruin your credibility more than by the time you get in front of a judge, you owe them 60 grand legitimately, and you've made no accommodation to pay them.
Well, and indeed, you have to do that if you don't want to get evicted during the pendency of your lawsuit.
Or you can give them a check that they can negotiate, and whether they choose to or not, that's up to them, as long as the money's
I've
there.
actually had that case in eviction court where a client, he was late on his rent, gave landlord a check, sent a landlord a check in the mail, and actually I lost that case because the judge said that in Colorado you have 3 days. Once you get notice that you need to pay your rent, you got 3 days to pay.
Well, no, I meant even if you timely and proactively, if you have a dispute with your landlord, say they say you owe $5,400, you say, no, screw you, you said $4,500, then, you know, and then you get a deduction because they screwed you on parking, then, you know, what it means is they give them a check for $4,200 on the first of the month. And you tell them you cash this, you're accepting our terms, which is you honoring the terms of the lease. And if they don't cash it, well, you know, they still can't evict you for non-payment. You got a legitimate dispute there.
My favorite thing was in federal court, you know how they had that 3-day rule? So they used to have a rule that said if you put it in the mail, we assume it gets there in 3 days for calculating time to respond. Even when we had e-filing for a time in federal court, they still had the 3-day rule on top of that, which led to some interesting time calculations for sure.
Well, I know what it led to was a lot of unscrupulous lawyers changing the timestamps on their machines or not advancing the timestamps on their machines and pretending they dropped it in the mail on a certain date.
Yeah, so not a problem anymore. But anyway, you know, that's the thing is landlord-tenant disputes are always rough because whether it's a residential or business.
And particularly now in the springs. I mean, what's happened here is both residential and commercial. There's been such a population and growth and boom that, you know, these landlords are really being pigs. And like I said, bulls eat, bears eat, but pigs do get slaughtered. And, you know, so, I mean, unfortunately, you've got too many people competing for too little space right now, which means that it's the landlords think it's their market. And they're really trying to, as Ryan says, squeeze every penny they can out of these properties. I mean, a lot of these places don't have proper certificate of occupancies. They definitely don't meet code. And, you know, I mean, they think nothing of just, you know, trying to cram you in and take every penny you can. I've never seen
and honestly, and the reason why they do it because they get away with it.
Well, yeah, I mean, let's face it, the Colorado Springs Codes Office clearly is not keeping up on a lot of these, you know, remodelings around here. You have buildings around here that were once a single unit that they have now turned into like 5 units where you don't even have 2 means of ingress or egress within 500 feet. You've got shared utilities and utility systems. I mean, I guarantee you it's a tinderbox above the drop ceiling. I mean, you got wiring that pokes out of the wall and then back into the wall. I mean, like, you got to be kidding.
But that's
right?
the thing is here's the deal. And I'll tell you, in my experience with construction litigation, these code inspectors are morons.
Well, they are.
They don't find things. I mean, honestly.
And especially
terrible.
And especially if you're one of the old boys in town, you know, then you're buddy with them because you've had coffee with them and you're going to shake hands and move on, right? But you know what's going to happen is some smart-ass guy from the East Coast, like me, with 25 years practicing law, like me, who knows this code inside and out, like him too, are going to absolutely dismantle these people because, I'm sorry, it is business. And when you get convicted of fraud, even if it's civil, well, that's worth some money.
But that's the thing is, again, people are always, you know, they talk about the legal system about being expensive and slow and all these things. And you know what? For a lot of cases, it is. But when we talk about landlord-tenant disputes, I mean, I'll tell you right now, in Colorado Springs, in El Paso County, if there's an eviction complaint, it gets basically thrown to the front of the line.
Come on, Ms. Monica.
Come on, we can have a hand on camera.
Monica,
One hand on the camera. One hand.
That is Ms. Monica's glorious hands. Once again, FHBeerWorks. Best beer in town, best manager in town, Ms. Monica.
Anyway, now that Joe's done with his plug.
Well, now, you know what? While we're on real property, let's talk about homeowners associations.
So HOAs there's a lot of HOA law. And the last time I sued an HOA was similar deal. What happened was this outfit called Warrior Golf. They bought out of bankruptcy a planned community, and so they controlled the HOA because they bought the prior developer out of bankruptcy. Well, Warrior Golf, their business is basically buying struggling HOAs that have golf courses and basically engineering it so the people in the HOA have to buy the golf course. And because in most of these golf course communities, the HOA actually does not own the golf course.
And then that means they got to pay to maintain it,
yeah.
too.
And so that was what happened in that case. What happened is that the HOA the HOA was controlled by the developer, and that is legal in Colorado. That is legal, and it's legal for a long time. They have to sell a lot of units before they have to give up that developer's control. And
most of the times they're contracting with aligned companies.
Oh no, that's
meaning that they got a piece of everything. Landscaping, snow removal, you name it.
Well,
they get a piece
of everything, and the issue is they negotiate in bad faith. So in that case, what happened was they ended up buying a golf course. This HOA ended up buying Warrior Golf's golf course, but did the HOA get an appraisal? No. Did the HOA's board discuss it first? No.
What they probably did is how much money does it owe? How much money do we need out of it? Okay.
Well, it was actually how much money they could return to the investors. Because in that Warrior Golf scenario, the guy running that Warrior Golf was actually syndicating his company to investors. He actually got in trouble with the SEC for unlawfully selling securities because all he was doing was emailing people and basically saying, I got this opportunity for you.
Well, now, and so here's an interesting thing. So they do this, and they basically rape the development until they're about 80-90% sold. But then they think that when they finally turn it over, their liabilities are gone. But they're not.
Well, so Colorado has some very tough construction defect laws. I'll put it this way. I mean, if I'm being 100% honest.
About shifting soils, radon, you've got a bunch of
but here's the real talk issue: is that everything in construction is defective because you can find someone who says I would have done it a different way, and because I would have done it a different way, what that first person did is defective. Now, the wisdom of that law is up to the legislature, but what I'm telling you as a matter of practice is homeowners have a lot of remedy against construction defects. In Colorado,
719-888-5882. Call Ryan and I. We're your number one remedy. Go ahead.
Nice plug. Joe's master of the plugs. Anyway.
I am.
Just not the hair plugs.
Shameless.
But I'll give you an example of construction defect law, how it saved a homeowner's ass entirely. So in this case, I was actually representing the construction contractor who had not got paid. They weren't paid to the tune of about $120,000 of landscape work. And what was going on is the homeowner had a contractor building him a house. This was in the Aspen, Colorado area. And the homeowner would come over to the job site every day and request certain stuff be done, out of the horse's mouth, if you may. And the contractors were then the assumption, well, the owner is asking for it. We'll do it, and we can send the bill to the homeowner.
And unless that stuff's in writing.
Well, but here's the thing, is actually, I got around that part. I got around the in writing part because, of course, my client didn't get anything in writing. I got around that part. The problem is that they countersued for construction defect. And what they did was they found another excavation contractor who's actually a competitor of my client to be their expert.
To come in and piss all over their work.
Exactly.
Well, that happens, yeah.
And so, but here's why I tell you this story is those homeowners were facing a mechanics lien lawsuit that they were going to lose. They had undoubtedly told these people to do the work.
Now let's talk about a mechanics lien. All right, so a mechanics lien is basically when you hire someone to come in and work on your property, within X amount of days of their last day on the site, they can file a lien against your property to make sure they're insured to be paid. and it actually becomes a priority lien.
So long story short on that case, because he was able to allege construction defect, my client's insurance company got involved and actually settled the case, paying him $70,000. Now, however, my client ended up getting paid most of that.
Ryan the Hammer Gilman, baby.
But that's at the end of the day, those guys got their asses saved because of the construction defect laws in Colorado, because they're so liberal and they're so homeowner friendly.
Okay.
So if you got one of those problems, 719-888-5882.
Joe O'Keefe, Ryan Gilman, and the little furry mutt is Jaeger. Hey, now, all right, hold on. We got someone back here, one of the other patrons. Give us a legal topic here for this final section.
Oh, God.
What's your biggest bitch? Let's go. Come on.
CSPD hanging out in the downtown district to increase DUI.
Well, look, I mean, let's face it. It is a thankless job. It truly is. And we should be rewarding them for being good cops with some good sugary donuts. That is absolutely a fact. Bad cop, no donut.
Right?
Bad cop, no donut.
But anyway, like when we talk about enforcement priorities in Colorado Springs, and I think any city of size.
Well, no, look, I'm
has-
telling you why they're hanging out along this main street. This is because the homeless have been tearing it up. It's all over the newspapers. You can read it in the Colorado Springs Independent, which, by the way, is an outstanding newspaper. And, I mean, what they're doing now is just like, they're making sure the homeless have been, like, clogging the intersections and bouncing off of people's hoods on false claims. They're absolutely harassing patrons of the businesses. And when you have such a renaissance down here, what are you going to do with it? I mean, we do have a homeless problem here in the Springs.
Look, all the Springs cops are doing is what the cops do everywhere else. I mean, I like my big.
I got news for you. I've been a lot of places where the cops don't do shit.
Well, they're following and honestly, this is where Joe and I our opinions will markedly differ. Because
I do disclose, I have a lot of friends in law enforcement, mostly federal, but yes, a lot of local ones.
And I'll disclose that I spent when I was in law school especially, I've defended a lot of homeless people over my career.
Hey, I've had a lot of family. I've had family that's homeless.
No, I've advocated.
I don't have a problem with the homeless. It's just that down here they're particularly aggressive.
I've advocated for the unconstitutionality of illegal camping rules. I've advocated for the unconstitutionality of public urination laws.
I think we ought to send him. Hey guys, here's a new program. We're going to hire a shuttle and send him to Ryan's backyard. When his fiance gets to meet him, watch how that changes.
But anyway, it's a problem because the thing is you end up with what we call quality of life offenses that happen because you have a homeless population that is big. And when I was in law school in Boulder is notorious for a bunch of homeless people. Colorado Springs' homeless population is
I'm making light of it, but I want to be clear. I did have an aunt who was homeless up until I put her in a place about 6 months before she died. Homeless I get it, and it's a real problem. But the problem here in the Springs, and I think in Colorado in general, is it's almost like a hands-off, don't touch it attitude. And then on the other side, you've got the reaction to that's coming out. Here in the Springs, we have a real problem with homeless.
But here's the thing: and this might be for someone who has no children a weird.
Can you hold this for a second while I rein in this dog?
Is that look, just like you're telling the story, when you have less than an ideal home life to give you good examples, it's amazing how things fall apart. And I can speak that as to my career as a criminal defense attorney.
To her, four walls were suffocating. That's when the demons would get in her head and she'd hear the noises. That's why she liked being outside, because outside, I guess, the voices got lost in the wilderness.
Yeah, but if we think about what crime, because when we talk about quality of life offenses, right? If she's camping in the park, camping on the beach or whatever, she's not. Again, I think it's you have to take people out.
You say that, but she also spent a bunch of time in and out of mental institutions, including after she nearly clawed the eyes out of a Greyhound bus driver and caused a bus to almost flip over.
But again, that's not because she was homeless.
No, it was because she heard voices and thought someone was out to get her.
And that's the thing is how we deal with mental health in this country is
horrific. We'll spend a whole hour talking about that. I'm my sister's guardian. She was once a brilliant lawyer, and our mental health system sucks. It thoroughly sucks. I don't even want to get into it. It's disgusting. We ought to be ashamed of ourselves. We're the richest nation in the freaking world, and we do nothing for mental health, and it affects every family in this country. And if you say it doesn't affect your family, you're lying or you don't know the difference.
But that's the problem we find a lot in criminal law is that a lot of people are not what we call bad people.
No.
They're people who have families. They're people who have friends who manage.
Unfortunately, our mental health system does lock up most people. A lot of our prisons, besides the bullshit mandatory sentencing drug laws, they're mentally ill people, right?
Well, of course.
We're locking up these people when we can help them otherwise, and non-violent offenders, and letting violent offenders walk free. Think about that. Why? Oh, I don't know, because maybe he was black and sold a dime bag, or maybe this crazy person pulled a knife because in their mind they thought they were being surrounded, right?
I mean, and that's what we're supposed to have is an individualized justice system to ferret out all that stuff, but we don't.
Well, but the legislatures and the feds have taken that all away from the judge's hands. They have.
Well, and that's actually, we say that, but you know what? Even down to the officer on the ground who has officer discretion whether or not to make a charge, to the prosecuting attorney who has prosecutorial discretion whether or not to pursue a charge.
You know what that means? If you're a white guy and they know your daddy, they're going to cut you a break. But if you're black,
that's what it means every
or
time.
you're of color, watch the fuck out. I'm sorry.
And that's the thing about
25 years of practice in law, and that just plays true.
But it's how our system works, and again, there's some institutional things that cause. So, I mean, for example, when we talk about that, when we look at racism in the criminal justice system, we also need to control for the fact when we talk especially about the black community. And let's look at where the black community lives in our country. If we were talking about the South, where most black America lives, we're talking about Louisiana, which until recently you didn't have to have a unanimous jury to get convicted. We talk about Mississippi. We talk about Alabama.
Hey, look, I lifeguarded in a state and spent my summering in a state that up until 1983 still had segregated schools and white-only, black-only signs on bathrooms. Out here, I don't think it's so much the black community as it is the Hispanic community that is absolutely
especially in Colorado. But we would be remiss if we forget in the 1920s the Klan ran this state, and we would be ignoring our history that for a long period of time organizations like the Ku Klux Klan had immense political power, and they were able to legislate Jim Crow, and
they probably said that.
Oh my God.
I mean, I'm sitting back east. It's like 1997, and I'm working a poll. And I have another Democratic poll worker, and I'm not a Democrat, by the way, I'm a registered independent. But I had a Democratic poll worker show me his card, his KKK card, and then begin Catholic and Irish jokes. We
live in an interesting world, but that's the thing is we have people in positions of power, especially when we talk about in the voting scenario, like poll watching, right? I don't know how they did there.
Speaking of voting.
Oh yeah, today's election day.
Did you get your ballots in? If not, hurry up. There's still boxes out there. You can get it done. So anyway, listen, we're signing off because we're running out of video, and quite frankly, they may cut us off a beer soon.
Never.
Never.
Miss Mont, she would
never.
Not us.
No, because we burned the place down. And in the meanwhile, if you want to participate, FHBeerWorks, Tahone Street. We'll be here again next Tuesday, 3 p.m. Come on down.
Anyway, have a good week. Have a good life. Stay out of trouble.
Proof God loves mankind most of all.
If we could get Jaeger to bark at the end, like if we could get a little sign-off bark.
No, maybe we can get him to roar.